Have you ever had one of those light bulb moments? A brilliant idea for a book, an invention that could change everything, or just the perfect name for a new business? Well, in our world that's so driven by new ideas, knowing how to protect them isn't just a good idea, it's absolutely essential. So let's dive right into your guide to intellectual property.
All right, to get our heads in the game, let's start with a little riddle. Think about three things that are just massive successes, but totally different from each other. The super secret formula for Coca-Cola, the tech and design of an iPhone, and, of course, the magical world of Harry Potter. What's the one thing that connects all of them?
You got it. It's intellectual property, or IP for short. Every single one of them is an incredibly valuable asset, not because of the physical stuff they're made of, but because of the idea, the creativity, the intellect behind them. And that idea has powerful legal protection.
Now, to really wrap our heads around this, we gotta start with the basics. Let's talk about the word property. We usually think of physical things, right? A house, a car. But legally, property is really about the rights you have over something valuable. It's the law saying, yep, this is yours and we'll back you up.
So, intellectual property takes that exact same idea of ownership and applies it to something you can't physically touch, the creations of your mind. It's the whole legal system that says your ideas, your formulas, your creative works, they have value, and you can own them.
Okay, so how do you actually do that? How do you protect these amazing creations? I want you to think of it like having a special toolkit. And for different kinds of ideas, you're going to need different tools. We're about to look at the three main tools that every creator, inventor, and entrepreneur absolutely needs to know about. The big three in our kit are copyright, which is all about protecting your creative expressions. Then you've got patents, which are for your inventions, and finally trademarks, which protect your brand. Each one has a very specific job to do. Let's pull out that first tool and see how it works.
First up, copyright. Now, this is a really important distinction to make right away. Copyright doesn't protect a general idea, it protects the specific, tangible expression of an idea. It's all about protecting the how you said something, not the what.
So what are we talking about here? We're talking about literary works, like books and articles, dramatic works, like plays and scripts, musical works, songs and compositions, and artistic works, everything from paintings to photographs. For instance, the general idea of a young wizard who goes to a magical school. You can't copyright that. But the specific way J.K. Rowling wrote the Harry Potter books, those characters, that plot, those exact words, that specific expression is what's protected by copyright.
And here's one of the coolest and maybe most surprising things about copyright. It is completely automatic. The second your original work is in what's called a fixed form, meaning it's written down, it's recorded, it's saved on your computer, bam, it's copyrighted. You don't have to file a single piece of paper to get that basic protection.
And get this, that protection lasts for a really, really long time. In most cases, it covers the creator's entire lifetime plus another 70 years after they've passed away. It's designed to protect an artist's legacy and give people the security they need to work on those huge, life-changing creative projects.
All right, let's put the copyright tool back and grab our second one, patents. Now, if copyright is for artistic expression, patents are for practical invention. This is the tool you reach for when you've come up with something new and useful that actually solves a problem in the real world.
But you can't just get a patent for any old idea. Your invention has to clear three pretty high hurdles. First, it has to be genuinely new, as in nobody's made it public before. Second, it must be useful. It has to actually work and have a practical purpose. And third, it has to be unobvious. This means it needs a real spark of invention, not just a simple little change that anyone in that field would have thought of.
And here's another huge difference from copyright. Patents are absolutely not automatic. You have to go through a whole formal process. Once you've got your invention, you have to file a super detailed application with the patent office. And that application has to spell out exactly how it's made and what it does, and then make very specific claims about what you want your exclusive rights to cover.
So what do you get in return for sharing your invention with the world in that application? Well, the government gives you a monopoly on it for a set period of time. For most patents, that exclusive period is 20 years. After that, your invention enters the public domain, and anybody is free to use it.
So let's just quickly recap the two. Copyright, it protects the expression of an idea. It's automatic when you create something, and it lasts a super long time, life plus 70 years. A patent, it protects a new invention. You have to apply for it and get it granted, and it generally lasts for a much shorter fixed period of 20 years. Okay, on to our third and final tool in the main kit, trademarks. So, let's say you've written your book or you've invented your amazing new gadget. How do people find it? How do they know it's yours in a super crowded marketplace? Well, that's what trademarks are for. They protect your brand identity.
A trademark can be a word, a logo, a symbol, a design, pretty much anything that tells customers where product or service comes from. Think about it. When you see that Nike swoosh or the iconic Apple logo, you instantly know who made that product. That's a powerful trademark at work.
But that brings up a really good question, doesn't it? Can you just grab any old word or symbol you like and call it your trademark? Well, not quite. The law has some really important rules to make sure everything stays fair. For a trademark to get official registration, it has to be distinctive. You generally can't just trademark something that's clearly descriptive, like you couldn't call your Apple company Red Delicious Apples. It also can't be misleading, and critically, it can't be so similar to a trademark that's already out there that it would confuse people. The whole point is to help customers, not confuse them. A registered trademark is initially good for 10 years, but here is the amazing part and a huge difference from patents. As long as you keep using that trademark in your business and you file the renewal paperwork, you can renew it over and over forever. That's how a brand like Coca-Cola, which is over a century old, still has its trademark protected.
So we've gone through the big three tools in our creator's toolkit, but that's not quite the whole story. The world of intellectual property is way bigger and more complex than just that. It's really this delicate balancing act between protecting the rights of creators and doing what's best for the public.
Hey, remember that Coca-Cola formula from the very beginning? Well, it's not patented. If it were, it would have expired a long, long time ago. It's protected as a trade secret. This is another type of IP, and it's basically confidential info that gives a company a competitive edge because it's a secret. And even these powerful protections aren't without limits. This quote really gets to the heart of the issue. The whole point of IP rights is to encourage innovation, but they can't be used as a weapon to completely shut down all competition or unfairly block trade. There's always the public interest to consider. And that really leaves us with the ultimate question. On the one hand, we absolutely want to reward creators and inventors for their hard work. But on the other hand, we want society to be able to build on old ideas to create new ones and keep moving forward. So where exactly do we draw that line between protection and progress? That's the constant, fascinating challenge at the very heart of intellectual property.